Hi everyone, final session, Reform Proposals for Sustainable Groups. My name is Mark Taylor. I'm a researcher at the FAFO Institute for Applied International Studies here in Oslo. I'm not going to hold you up. We have a very interesting set of presentations here. It was meant, just two words, it was mentioned earlier today about the Forum on Business and Human Rights that was held in Geneva over the last 2 days, and like a couple of you in the room, I was also there. And one of the participants in one of the sessions made a comment that I think is quite appropriate for this session. Basically to the effect that when the corporate group is excellent at combining or aggregating the interests of the parent when it comes to profit, and just as good at dispersing responsibility across the separate entities of the group when it comes to responsibility for social or environmental harms. So the group becomes a core mechanism for multinationals in managing irresponsibility for externalities. Global multinationals shift activities, ownership relations, and risks across national boundaries, and unsustainable business becomes a moving target for citizens and regulators. And sustainable groups that we want to talk about here becomes a bit of a mystery for investors and consumers. So to help us think a little bit more clearly through some of these mysteries, we have three people lined up for us. First up on the agenda is Tineke Lambooy. Tineke, the floor is yours.
Thank you very much to get again the opportunity to present one of our studies. This is a study on group law, and that has not only been done by me, but also by Jelena, Stamenkova van Rem, she's here, Linn, Anker-Sørensen, and Muzaffer, Eroglu, but he's in Turkey, couldn't come here. The topic of our study is corporate law analysis on barriers and opportunities for groups to effectively address climate change. We are here because it's 5 to 12 for research on corporate law and climate change. There's been a lot of research in other disciplines, but not in corporate law, with a focus on climate change. As you may have understood so far, the Sustainable Companies Project has assigned the task to all the members to make a mapping paper of their own jurisdiction on corporate law aspects and sustainability. On the basis of these mapping papers, we decided to make three cross-cutting studies that lead to three cross-jurisdictional chapters in a book that will come out next year with Cambridge University Press. And the first chapter is on corporate purpose, the second on environmental reporting, and the third one is on corporate groups. So that is the study that I will present now. The research question in our chapter is: what are the barriers and regulatory best practices in corporate law in relation to preventing and mitigating climate change impacts by corporate groups? You can read multinational companies. And like a sub-research question, we also tried to identify how can corporate law assist groups to adopt and implement a climate change program. Well, I think you understand what the motivation is to look at groups. Groups have an immense negative impact on the environment and also on climate change. This has also been explained this morning. Reference was made to land conversion, deforestation, of course, the direct emissions by industries and companies, but also the emission of other gases and particles, which heat up pole caps and glaciers, and not to forget the lobby of especially the carbon-intensive industries against transition to a carbon-low economy. But at the other hand, there's also a potential for mitigation by multinational companies because they play a very, very powerful role in this world. And there are frontrunners that show leadership who really incorporate CSR or cradle-to-cradle initiatives or who are following the Carbon Disclosure Project. And if they succeed in defining their carbon neutral goals and in emission reduction and sink enhancement, introducing carbon offset programs to stimulate climate-friendly technology, and when they invest in sustainable forestry and forest carbon to restore ecosystems, then there is a good role to play by multinationals. What is the role of business regarding climate change? I mean, some business leaders say, well, that's for governments to solve, and we are here to see what companies can do. So we decided to look at a number of key documents. Well, these are not the only ones that we studied, but I briefly mentioned the European Commission strategy for CSR 2011 to 2014, then the Commission proposal for a directive on corporate non-financial reporting this year, and also the GRI G4 guidelines also this year, and the OECD guidelines, the UN Global Compact and the Carbon Disclosure Project, and the World Business Council for Sustainable Development that has 200 companies that are a member to that, which produced the document Vision 2050, plus a framework for action from Vision 2050 to Action 2020. If we look at the EU strategy document, we see that CSR is defined as the responsibility of enterprises for their impacts on society, and that they should have a process in place to integrate environmental and other concerns into their business operations and core strategy, that they should maximize the creation of shared value, and that they should identify, prevent, and mitigate their possible adverse impacts. To avoid negative impact, they are encouraged to carry out risk-based due diligence, and to stimulate their positive impact, enterprises are encouraged to adopt a long-term strategic approach to CSR. So climate change is undisputable a CSR theme. So an enterprise is required, according to this EU Commission document, to integrate climate change in its core strategy with a long-term strategic approach, to also have a process in place for implementation in business activities, and to perform a risk-based due diligence that includes climate change impacts as a theme, and to disclose information on this. In the same line, we can see that in the European Commission proposal for a directive on corporate non-financial reporting, that the Commission expects that the law can ask from companies and groups that they disclose information on policies, risks and results, amongst others on environmental matters, again, including climate change. Well, to think of these European Commission views and also World Business Council views, they all talk about enterprises, and they talk about responsibility of enterprises, so multinational companies. But what is the law on the ground? What do companies have to deal with? So what we did in our research, we scrutinized all the mapping papers, and we asked ourselves a number of sub-research questions, like, are there any specific approaches on climate change? Does the corporate law require from a company, from a group of companies, to have an objective or a program on climate change? Does this group have to report on climate change impacts? Or more general, is there any regulation on group missions or objectives? And then a second question is, what is a group? How is a group identified? And how do you identify its members? And also important is to know what corporate governance instruments are available for a multinational company to implement a program, if they have a program. So do they have an instruction right? Does the top management have an instruction right to impose that program on all the members of the group everywhere in the world? And then enforcement. If one of those subsidiaries doesn't comply with the group program, what do you do as a top management? And if other stakeholders are impacted by non-compliance with the group program, do they have a right to go against the subsidiaries or against the top parent company? So then we're talking about liability. And the question is there an enterprise approach in corporate law or a legal entity approach? Well, these were all the mapping papers, all the countries that produce mapping papers, not all the flags on this world map, but the ones on top of that. And the general findings, actually, in all those mapping papers are that legal personality of a group company, and thus the distinction between this company and its shareholders assets, liabilities, rights and duties, is overall an unquestioned principle. So there's a legal entity approach in almost all jurisdictions. Generally, the parent is regarded as a shareholder with no special rights or duties in regard of the other group companies. Hence, there is no enterprise concept like there is in these documents that I showed before. And also, we see this enterprise concept, for instance, in European competition law or in Dutch co-determination laws that also is based on the economic concept of an enterprise, not on one legal entity. And actually what we see in economic reality. However, most jurisdictions recognize groups when we talk about consolidated reporting. And also some jurisdictions recognize groups when they talk about bankruptcy or competition, tax and capital market regulations. Then we had some interesting findings in national corporate laws, especially in Germany, Slovenia, Hungary, Turkey, Albania, China and Japan. And Janet Dine will elaborate more on the German and Albanian examples. But it's interesting to see that there are jurisdictions that recognize a group concept and a common objective of a group. And also that other companies have to subordinate their activities to this common objective. Other interesting findings were that in Brazil, groups have to register, and that in Japan, a parent company has a right to obtain information from subsidiaries. Well, any shareholder can ask information, but this goes further than the normal right of a parent company, of a shareholder, I mean. In the Netherlands, a works council has a co-determination right, so it can influence the decisions taken by the board. And then interesting that is in Spain, the environmental liability laws link to the commercial code that defines which companies are part of a group. So that's also an interesting approach. In Albania, we have an enterprise liability, but Janet Dine will elaborate more on that. Then I have two more topics. One is the barriers. So the question was, what barriers are there in group law, or actually in national corporate law in regard of the treatment of groups? Well, in none of the jurisdictions, the corporate law regulates that the parent company defines a CO2 mitigation strategy for the group, so that's a barrier. Nor that it implements this, and nor that it reports on CO2 emissions of the group. Well, maybe in the UK I have to study that a little bit further. Generally, climate change is regulated in environmental laws, but these only apply within the territory of the jurisdiction. And they don't connect to corporate governance and corporate law terminology and instruments like group policy and consolidated reporting. So there actually is a disconnect between regulators' environmental policies and ambitions and the instruments that they could have used when they would have connected to corporate law. Our recommendations, based on the best regulatory practices that we found in the mapping papers, would be that every jurisdiction would have a requirement to register a group, because that helps a government to implement climate change policies and laws if they know which groups have the top parent in their jurisdiction. And then secondly, to require from top parent companies to define group mission statements, including a climate change program, and also to look that the top parent company has a power to implement this, and we found some good examples in the mapping papers. And thirdly, that they disclose their climate change impacts, risks, programs and results, like also in the EU documents is apparent. And the second set of recommendations is to link any type of law in relation to climate change to a concept of groups as we use that in consolidated reporting, because only then you can avoid a discussion on which entities are belonging to this group and which entities' emissions we should calculate when we calculate the group emissions. And also for accountability, that would help when you know for certain which entities are part of the group. And only then a group-wide organizational change can be effectuated in a structural and transparent way. Well, finally, the conclusions. Corporate laws still operate as purely technical and mechanical bodies of law. They only seem to serve the facilitation of incorporating a business into a single legal entity. And corporate laws have in their developments really not followed the developments in the global economy. They miss the development that a great part of business is pursued through international corporate groups. And they also miss the development that there are expectations from the EU Commission and from the World Business Council and other organizations that enterprises and groups have to ask in a corporate social responsible way, and that they have climate change programs. Historically, corporate laws are designed to regulate formal and administrative aspects of establishing and functioning a company, and they are not seen as the normative rules, not seen as providing normative rules, like how should a board care for employees or environment or consumers, because that is assumed to be part of other bodies of laws. But there are exceptions, because corporate law does contain rules, and especially corporate governance rules do contain rules aimed at protecting shareholders and creditors. So why do we only protect these type of stakeholders by corporate law and not the other stakeholders, the environment and employees and others? Well, many companies and regulators and academics still argue that the Company Act should only regulate technical and formal and financial aspects. And yeah, that gives a lot of arguments, arguments to lobbyists who want to obstruct the change of corporate law into also a more normative system of rules. And that is where I want to end the presentation. Thank you very much.
Thanks, Tineke.